All right, welcome today. Um, my name is Kristen Linscott with Plano Public Library. We're really glad to have you with us today to learn about intellectual property, patents, trademarks, and trade secrets with the United States Patent and Trademark Office. Thanks to Reynaldo Vasquez, who is the Regional Outreach Officer for the U.S. Patent and Trademark Office here in the Dallas area. Thanks for being with us, Ray, and thanks for bringing this great information to our community.
Thank you.
You bet. Caitlin, did you want to give the instruction about chat and Q&A?
I can. If you have any questions during today's program, you can find the chat, which should be located at the right-hand corner of your screen, or it might be in one of the Zoom panels. There is Q&A and chat. Feel free to use either of those to post any questions that you have during today's program. We will have presenters and staff monitoring that to assist you.
Thank you so much. And I neglected to introduce my colleague Caitlin Tips, who's fantastic, and we assist with small business development and are happy to welcome you to many other programs of the Plano Public Library. So without further ado, we'll turn it over to Ray Ronaldo and get started on learning about patents and trademarks. Thanks so much.
Thank you. Hello, everybody. My name is Reynaldo Vasquez. You guys can call me Ray. I'm the Regional Outreach Officer here at the USPTO Texas Region Office. Pretty much what that means, I am a program manager of outreach activities that we do throughout the year. So a lot of IP education, stakeholder engagement, and recruitment efforts that we do for the US Patent and Trademark Office. Just a little bit about myself. I came from the SBA world, so I used to do economic development for about 11 and a half years with the SBA, and then I transitioned over to the USPTO. Before that, I was with ICE, doing purchasing for a detainee camp, a different life. I tell people it's a different audience there, definitely. And then before that, I was with the US Army. So I'm glad to be here today, just teaching a little bit about intellectual property and what the USPTO does. I'm gonna go ahead and pass it over to my colleagues, Osama and Jason, so they can do a quick introduction. I'll go first, Osama.
Hello, everyone. My name is Isama Ongba. I'm one of the supervisory patent examiner here at the Texas Regional Office. I work mainly in the mechanical area of the office, and I've been with the office for a little bit over 25 years, and glad to be here.
Hi, everybody. I'm Jason Bryan. I'm a primary patent examiner at the USPTO. I'm doing an outreach detail as an outreach coordinator. And so I normally examine applications in the area of computer architecture. And I've been at the patent office for around 14 years now. So nice to see you all.
Thank you, guys. So I'm gonna go ahead and start with the presentation. So here you see the USPTO logo. Do know I still want to say we are the only federal agency that actually has our federal logo trademarked. One of the reasons is because we are the agency that actually does that. But we actually didn't do that not too long ago, just about 2 years ago. We actually trademarked the USPTO logo just to show precedence and then also help with scam prevention, because even government agencies get targeted as well. So you on to the next slide. So today we'll be covering intellectual property basics, just a fundamental of IP, and specifically what the USPTO is and how we work and resources available for individuals. So next slide. So do know that IP rights have been in the US Constitution. So they've been here since the beginning. And a lot of it is because our founding fathers were inventors themselves. So they recognize the importance of intellectual property, the rights. So if you look up Article 1, Section 8, Clause 8, it talks about intellectual property rights being protected within the US Constitution. So we are one of the longest agencies, the U.S. Patent and Trademark Office. Of course, we've developed, especially now since technology has advanced so much. And we really focus on three main things in the outreach component, which is IP education, stakeholder engagement, and recruitment. We try to focus on that specifically to try to help with economic development. And since there is a direct correlation with IP protection and economic development, it's one of the things that we try to talk about a lot. And we even have accountability reports that we publish every year. At the end of every fiscal year, we have what we call accountability reports that talk about metrics, specifically in the patents and trademarks data, which you can even break down through state as well. So next slide. Here you see a snapshot of the USPTO. So for fiscal year 2023, we still have about 13,500 employees. Most of the USPTO are patent examiners. So we do need people with subject matter expertise, basically technical backgrounds. So a lot of the examiners will be engineers by trade, some scientists as well that helps us examine technologies. And we need them to really understand technology because they're examining things that are supposed to be innovative and new, novel and useful. So they have to bring that terminology and that technical background to really understand what they're examining. We do have also trademark examining attorneys, and those are the ones that actually handle all the trademark applications. And then we have administrative patent and trademark judges, and those judges help with the ex parte appeals that happen through the agency. In the middle, you'll see the patent filings that we see and then the patents issued just for fiscal year 23. If you look up the accountability reports and the numbers that we report every year, you can still continue to see an increase on patent and trademark filings. So that's a consistent rise that we continue to see. That's why one of the biggest issues that we have is actually trying to find individuals to work for the USPTO with that technical background so they can help us keep up with the demand. Do know that the US PTO is an agency under Department of Commerce, and we are a fee-based agency. So what that means is that we operate based off the fees that we collect on patents and trademarks. In the right-hand side, you do see the trademark applications and registrations. Trademarks are typically higher to patents, and a lot of it because trademarks are more easy to understand and easier for people to do on their own compared to patents. Patents is a lot more difficult to understand, and really, even though we do provide pro se resources and incentivize individuals so they can do it themselves, it is not the easiest thing to do successfully for individuals to file for patents and be successful. Down here, you do see the USPTO headquarters in Alexandria, Virginia. And before we were only in Alexandria, Virginia in headquarters, but thanks to the Americans Invents Act, you go to the next slide, Jason, we were able to expand to provide regional offices around the nation. And this allows us to be more accessible to the public, create collaborations such as this one that we're doing with the Plano Public Library, and really be able to educate the public a lot more. We do have a new office coming in soon. The UAIA Act in 2024 helped us establish a new regional office coming in, and that just shows Congress wants to do more outreach and IP education to the public. The more people really understand intellectual property, the more they're likely to use it. So the new Southeastern Regional Office will be headquartered in Atlanta, Georgia. Their area coverage isn't still set, but they should be helping us in the Southeastern region. So here at the Texas Regional Office, currently we have 8 states, the ones you see highlighted in blue. But so Atlanta will probably be taking a state or two away from us to help us do outreach as well. And next slide. Here you see our Texas regional office in Dallas. So there's always a competition for bids and people trying to get a regional office for economic development purposes, as you can probably tell. But having the proximity of Dallas helps tremendously. But not to say that we can't be accessible to Louisiana, Arkansas, and the other states that we cover. But for the most part, the office is just more accessible to the Dallas local area, and we do provide public search facilities, examiner interview rooms, hearing rooms, and public meeting spaces for the community. And for the most part, people that go into the office are patent examiners that wish to have a local office. They do have the flexibility to telework 100%. So most of them do take that advantage, but we have some patent examiners that to go into the office for routinely purposes, so just trying to get away from that home office environment. And then we do have also PTAB judges that come in for specific hearings or monthly or weekly meetings. And then management and staff such as myself that just go in for outreach purposes to work with local communities and do local outreach. So yeah, if you're ever in the area, you want to visit us, feel free to send us an email and we can accommodate your visit as well. So next slide. So I'm going to pass it over to Jason, and then Jason's going to cover the fundamentals of IP or the basics of intellectual property.
Okay, thanks, Ray.
Thank you.
Okay, so I guess we'll start here with what is intellectual property. So on the right here, you can see more traditional conceptions of property that you would think of, like real estate or a car, physical, tangible property, whereas intellectual property is more like it's creations of the human intellect. And so the main purpose of IP law is to encourage the creation of that kind of creation and so that it can be built upon and all that. And so it gives, in order to achieve that, it gives people and businesses rights in these creations of the human intellect. So to give some examples, just so we can kind of understand in a familiar context here, look at the intellectual property that's in a mobile phone. Lots of different categories of intellectual property here. Design patents, which is more like the ornamental type things, like the shape of the home button, the curve of the screen. Copyrights for the software code itself, the instruction manuals, potentially the ringtone. Trade secrets, we don't know because they're secrets, but there could be certain aspects of a mobile phone that could be covered by trade secrets. Trademarks would be like the brand Samsung and the product Galaxy Note. And then patents would cover some of the more functional aspects: the camera, battery, screen, antenna, data processing methods, and the hardware semiconductor circuits within the phone. So there's a lot of different intellectual property, and there will be I can tell you there will be tons of patents alone going into something like a mobile phone. So that's on top of all the other types of intellectual property that are already in there. So it's just gives you kind of a context of, you're talking about a lot of different aspects of intellectual property that come into bringing a product like a mobile phone to market. And so I'll talk about U.S. patents specifically. So one key thing to understand is the U.S. government grants a patent to give the patent owner. It's called an exclusive right. It's not a right to actively do anything to make and use your invention. It's an exclusive right, which is a right to exclude others from making, using, selling, offering for sale the same invention in your claims, or in the United States, or importing the claimed invention into the United States. This exclusive right is granted for a limited time, and you'll see in a few minutes there are different patent terms depending on the type of patent that you get. And so, and this is kind of a key aspect here, is that it's in exchange for the public disclosure of the invention. So, getting back to that goal of intellectual property rights, the goal here is that you disclose what your invention is to the public, and that can be used and built upon and contribute to the general knowledge. In exchange, you get, for a limited amount of time, the ability to exclude other people from making and using your invention. So it gives you a competitive advantage, while the public gets the benefit of the disclosure of your invention. These rights are territorial, meaning that, so you can see here, it says that you can prevent others from doing this, from making, using your invention in the U.S. or importing into the U.S. But because it's territorial, a U.S. patent only really protects you within the U.S. Other countries will have their patent offices and their procedures to get patents in protection there. But if you are, say, developing a product that you're going to, be marketing, selling worldwide, that's something you have to think about, is which countries you want to apply for patent protection in. There are some streamlined ways of doing that through PCT applications and things like that, but there is no worldwide patent. So just something to be aware of. So we'll be covering here just U.S. patents, and so this will only be that will only get you protection in the United States. The last point here is just that these are kind of criteria. They have to be new and useful process, machine, manufacture, composition of matter, or improvement thereof. That's kind of what the general subject matter of a utility patent would be. And you can see here a very early dated patent, 1890, Thomas Edison's light bulb there. So moving on. Now we're going to talk about the different types of patents. As I talked about before, so this is the first type of patent is a utility patent. It is specifically, it covers the functional. You'll see with respect to other types of patents, this covers usually functional types of things as opposed to designs. It covers the categories of process, machine, article of manufacture, and composition of matter. So a lot of the things that I examine as a patent examiner fall under this. A lot of the computer architecture stuff falls under this. So these are kind of broad categories and stuff, but you'll see things in the mechanical arts and things like that too. So with the utility patent, we were talking about the limited time that you get your exclusive rights for is 20 years from the date of filing of the first non-provisional patent application. You'll see in a minute there are provisional and non-provisional applications. So it's 20 years from the date of filing of your first non-provisional patent application. And this is an example here that Abraham Lincoln was the only president to ever get a patent. He never actually manufactured it or anything, but it was a patent for a device to lift boats over shoals. And so that's just kind of interesting. That would be an example of a utility patent, a very early example. And then so the next type of patent is a design patent. And so this type of patent, you can see an example here of like a root beer bottle. And this protects the ornamental appearance of a product, as opposed to the functional aspects, which are covered by the utility patent. So this is going to be the way that it looks, the shape of the bottle, things like that, things that are ornamental in nature as opposed to functional. And this has a different term associated with it, with your exclusive right. It protects it for 15 years from the grant of the patent, as opposed to 20 years from the filing date of the first non-provisional. Well, you'll see some overlap with this in trade dress later on, so we'll get to that. But there is, just so you know, there is overlap between the different types of patents and overlap in products and what parts are protected by what type of intellectual property. So you'll see that as we go along. The last type of patent is a plant patent. Protects different types of plant varieties up to 20 years from the date of filing the first non-provisional patent application is a term for that. I don't see many of these. I don't work on these, but yeah, they're out there. And here's an example of a poinsettia plant. So yeah, from 1953. Moving on now to those are the types of patents, but this is the process by which you would get a patent. First, you would start with whatever new idea you come up with, and it was one of the kind of probably early on things you would do is maybe go and search Google patents and see if it's done before, see if you really have a new idea or not. One of the requirements for a patent is that it's new, novel. And so there's also resources on the uspto.gov. We have a patent public search now that's kind of a version of the database that we search as patent examiners that you can go out, and there's a very simple version of it and a more advanced version of the search out there available that you can go and do a preliminary kind of investigation to see if your idea is already out there or not. And then the next stage after coming up with your idea could potentially be to file a provisional application. Now, provisional application is kind of like a placeholder application. That's not what comes to my desk as a patent examiner. It's a placeholder. It doesn't have to be complete. For example, it doesn't have to have fully the claims don't have to be fully fleshed out and written at that point, but it gets you a filing date that you can claim priority back to with your regular application. So it kind of acts as a placeholder for that, and then within 1 year of that, there's also, it's got cheaper filing fees and stuff like that if you need to raise more money to do that, or there might be other reasons that you want to just get that placeholder date in place early on, and then while you're still working on getting the other aspects of the full application ready. So if you do file a provisional application, you'll secure that filing date, because in the US we do operate on a first to file basis now. So whoever files first usually gets the invention, and somebody else could file as well. So the earlier the better. It's another reason to do a provisional as early as you can. But after you file that, you have 1 year then to file what's called a non-provisional application. And that's kind of your fully fleshed out patent application that'll have all the aspects of it. The claims will be written. It'll have all the requirements for a full-fledged patent application will be there. But you'll have, and then this application, the non-provisional application, is what comes to my desk as a patent examiner. So once you file your non-provisional application, it can take up to, say, maybe 18 months. It really depends on what art you're in, what art your invention is in, and what the patent office's resources look like behind that art and things like that. To say how long it would take to come to my desk could be up to potentially 18 months, and then there will be a back and forth between. Usually, it's a patent attorney will be filing this, and I will do back and forth with the patent attorney, and we will try to find out. I'll make sure that the patent application is in compliance with certain statutes, and that it is truly new and novel. I'll do searching on my end, the same kind of searching that you would do up front that we discussed earlier, to make sure that your invention is not already out there or obvious. And so that back and forth can it could be up to about a 2-year thing before the first round of that goes. And then there's obviously, for fees, there's the ability to continue after the first round of back and forth between the patent examiner and the patent attorney. But that's a little detailed, but just to give you kind of a rough idea of how that process works. There's a couple of back and forth things between the patent attorney and the patent examiners before they say a prosecution is closed, and then you pay a fee to reopen it, and so the process can go on. So the point being, it can take a while before eventually we'll come to some sort of an agreement, potentially, hopefully. If you are able to get a patent, it will be allowed, and you'll get a patent, and the term of that patent that you get will run 20 years from the filing date of the first non-provisional applications filed. Hopefully that just gives you kind of a background and an idea of what I do and how the process works. It can be obviously a lot more complicated than that, but now we're going to kind of just shift a little bit here to just looking at some kind of weird and wonderful patents, just to give you these are just kind of fun little examples of patents that are out there that are just kind of interesting. So this one is a TV control device that can adjust the volume and more from the comfort of your sofa. Variable adjustable length and considerably less expensive, and functions efficiently. Might be thinking of a remote control, but this is an older one from 1976, an actual adjustable length arm to reach out and do that. So that one's pretty funny. Then there's a fresh breathing air device, so that you can breathe in a smoke-filled room, so you can get fresh air through a tube. So yeah, this one's kind of a little strange. You wouldn't really think of this necessarily, but that's how you get this drawing shows how you actually use a tube down into the toilet to get fresh air from the pipes in there, which I don't know if I would call that fresh, but I guess that works. If anyone's ever seen the movie Kingsman, there's a scene where room's filling up with water and they have to try and find a way to breathe, and they use this method actually in the movie to find a way to breathe in a room filled with water. So it's just kind of an interesting thing. Apparently, that works. So another one is a pet umbrella. It's combines an umbrella with a leash to protect your pet from inclement weather. This one's kind of funny, just kind of a cool little thing there for dogs. A different one. That one's more recent. but yeah, makes sense. That's a nice thing to have there. So we just thought those were kind of interesting ones to talk about. But that kind of brings us to the end of the patent section. So we'll move on to trademarks now. So what is a trademark? Trademark's a word, phrase, symbol, or combination of words, phrases, and symbols or designs. The main point is they identify the source of the goods and distinguish it from the source of one party from another. So it's a source identifier is what it is. It tells you who made this good, where it comes from. And a service mark is the same, except it just has to do with services as opposed to goods. I think generally collectively they're referred to as trademarks. But yeah, and so these the main idea here is that you can use a trademark in your business and you will have some local rights to that, but in order, if your good business is going to expand nationally, for example, something like that, you would want to register that trademark probably with the USPTO to get nationwide coverage and stuff. So that's kind of the basic idea what it is there. Some examples of trademarks here are like the Starbucks, the words themselves are trademarks, and their designs, like the logos, the Nike logo, the Target logo. These are just different examples of what can be trademarks. It actually expands beyond this. In some instances, you could have these non-traditional marks of colors, the color Tiffany blue of the Tiffany jewelry boxes, UPS brown, and the John Deere green and yellow color scheme, like all their tractors and stuff have. Those are things that they're more non-traditional type of things, but those can also be considered trademarks because they can indicate the source of your goods or service. And then again, non-traditional marks here would be someone has it would be scents. Someone has this liquid power. It makes your exhaust smell like grape, apparently. I don't know. And then I think Play-Doh has a very distinctive kind of smell and stuff like that. So that could be something too that would be, it would be associated with that, particular brand of product. And so other non-traditional marks would be the sounds of the Pillsbury Doughboy saying, I think he says tee-hee when you poke his stomach or something. And then the NBC has a little chime. And then the sound of the Mario coins, all those sounds can commercially identify the origin of products and services. So they could potentially be considered trademarks. On a related note, and this kind of goes back to the design patent thing, it just shows you how there's a little bit of overlap in kind of ornamental aspects of things here. So the ornamental aspects of, say, like Doc Marten boots, the way that it has like yellow stitching in a certain area and stuff like that. The shape of a Hershey's Kiss, the interior design of an Apple store, Coca-Cola's bottle shape. Those are things that might be covered under trade dress. They're ornamental designs, but they're very distinctive, and they've come to a customer would come to associate that design with the source of the product. And so that's an area where this ornamental designs and things like that can serve as trade dress, similar to trademarks. So it's kind of interesting aspect there. So then I'm going to move on to copyrights. And copyrights is legal protection for original works of authorship. This is where you see literary, dramatic, musical, artistic. This is where you see things more like, books and things like that, being that copyright gives you a bundle of rights. It gives the owner of the copyrights. They can make copies, prepare derivative works, distribute the copies, perform those works publicly, and display the works publicly. Those are kind of the bundle of rights that copyright gives you. And so these are, your music and things like that. Here's examples of things that would be covered under copyrights: songs, books, movies, sculptures. And again, I'll show you here. This is where, again, you see some overlap with trademark and copyright is logos, product design, packaging, promotional materials. These things can all be protected by copyright. Instruction manuals, software source code, and you might have patents on certain aspects of, like, we saw the mobile phone, but your software source code would also, that would be copyright protected there. So there's a lot of different overlap, and and different types of intellectual property that work together to protect products and things. So then just kind of moving on quickly to trade secrets. This is another form of intellectual property. You'll see some interplay between this again and the other forms of intellectual property. So this is information. It could be a formula, pattern, program, device, method, technique, or process. And it's used in business to give an opportunity to obtain an economic advantage over competitors who do not know or use it. So it's a secret. It's your secret formula. I'll give you some examples. It could be things like the formula for Coca-Cola. Could be things like KFC's 11 herbs and spices. You'll see in things like those formulas and herbs and spices, a lot of what happens with a trade secret is that there has to be like a reasonable steps to keep it a secure secret. And so things like you'll have like the KFC spices, individual people won't necessarily know what's in it. It'll be prepackaged and stuff like that for distribution to different employees and stuff like that. So there's a lot of control over who has access to, say, the Coca-Cola formula and things like that. You'll see a lot of things like that, maybe non-disclosure agreements and stuff like that to protect those trade secrets. But that will be a requirement of trade secrets, is that you're taking steps to keep them secrets. The Google search there might be some aspects of Google. It can be more complicated than this, obviously, and there is overlap. So Google might have certain patents on certain aspects of their overall search process, but then, how that fits into the overall process and things can be part of a trade secret. So there can be, certain aspects, maybe patents, certain aspects, maybe trade secret. There can be overlap and interplay there between them. And that kind of brings me to an important kind of topic of just this is something that people have to take into consideration when they're working on their products, their businesses, and bringing these things to market, and how they want to figure out how they want to protect their products with intellectual property. So, for example, with the trade secrets, and we always do tell everyone they should probably go and talk to an intellectual property attorney or patent attorney to try and help make these decisions. And because the success rate of doing pro se or filing patent applications yourself is not as high as having a patent attorney do it. But these are the types of things that you would need to look at here too. Is like, do you want to protect your product with trade secret, or do you want to protect your invention with a patent? So some of the benefits of a patent is you get exclusive rights but they're for a limited time, and a trade secret would last as long as it stays a secret. So as long as you're taking steps to keep it secret. So you have to take reasonable steps to keep it secret with a trade secret. With a patent, obviously, you're not going to be able to protect the same thing exactly with a trade secret, because you have to, part of the exchange with the government is they give you the exclusive right for the limited time, but you have to disclose how to make and use your invention in the application. And that application will be published usually 6 months after filing it. And so those are the kind of things you have to take into account, like which one's better to protect my intellectual property here. In this instance too, another thing to consider in that decision making is that trade secret does not protect you from reverse engineering. So if somebody gets their hands on your product and they're able to reverse engineer your trade secret, there's no protection for that. Whereas if it's something that you have a patent on, even if they get their hands on it and reverse engineer it, figure out what you're doing, that you're still protected with the patent. So there's different things to think about, when you're determining how to protect your intellectual property. And so the next slide is just kind of gets at this point a little bit more, but this is just kind of a summary of showing you the different types of intellectual property protections and the requirements, what they protect against, and how long they last. And these are just the kind of considerations you're probably going to use if you are bringing a product to market. For example, you're probably going to use lots of these different types of things, but trying to figure out where and when and which ones to use for what instances is the kind of thing that would be the consideration that you would take into account and potentially discuss with your legal representation. So with that, I will turn it back over to Ray to discuss the USPTO resources.
Thank you. It's a quiet crowd so far, so it must be the rain that we're getting here in the Plano area. So feel free to ask any questions you guys may have in the Q&A chat feature or box. And then at the end of the presentation, we'll open it up if we can to individuals. So I'm going to talk about USPTO resources. So we do recognize, here at the agency that going after patents and trademarks is not the easiest thing to do. It can be costly as well. So we do have resources available to the community, to the public, so they can really understand what's IP and also like how to take advantage and go about protecting your IP. So next slide. The number one resource I would say is our website. We have a lot of content, a lot of information in our website. Anything that has to do with intellectual property, in particular patents and trademarks, we share with the public. Data sets even for the patent system that we have. We have complete data sets, something that is used a lot by AI companies. And we also have policy updates. So I definitely recommend for you guys to check out our website and also subscribe to our newsletter. That's the number one way of communication that we have to the public. And we also have ongoing trainings that we do. So that's something else that you can take advantage of and get the alerts for. Next slide. We do have a specific inventor newsletter that talks more about what we call the innovation ecosystem, and this helps you get connected with innovation leaders around the nation. It's something that we like to encourage because we do notice that usually the subject matter experts or people interested in the area are within the system, but we also like to include others to provide additional feedback and get more exclusiveness and accessibility of other problems that we may have out there. When there's a lot innovation, doesn't really discriminate. It happens to everybody. Just underserved markets typically don't get represented because they're not in what we call the innovation ecosystem. So next slide. So we do highlight startup resources for individuals to consider. This web page right here talks about partners that we work with from the SBA and its resource partners to other federal agencies that may have research and development funds available, usually through the SBIR, STTR programs. So that goes hand in hand. We don't necessarily fund. We're not a funding agency or more IP education in particular, but we work with a lot of the organizations and we do a lot of interagency collaboration. So that's why we know there's an overlap. Our subject matter expertise is more in the IP world. And even do know that there's also state rights. Here in the state of Texas, for example, you can get a trademark for the state of Texas in case you don't want the USPTO, the federal national one. There's some businesses that decide just to do the trademark application just for the state of Texas. So we try to provide you information for states as well. Next slide. The Path to a Patent training series is something that we recommend for individuals to really help them understand what patents are and how to go about it. So we can teach you from the basics of what patents are to doing your prior art and research behind it to actually the filing of applications from provisional to non-provisional applications. And that way people can feel more informed, even if they have IP counsel, they feel more informed in the process and are able to make more informative decisions. Next slide. We also do have a 1-800 hotline specifically for inventors assistance. So anything dealing with patents in particular. Do keep in mind, I think I mentioned it in the beginning, but we can't give any legal advice, so we do always get the question of, say, can I get a patent for this or a trademark for this? We really can't tell. Even if you wanted to, you have to do research behind it to really know. And this is where our IP education helps you make those informative decisions. So that's why we have these resources like the 1-800 hotlines. And they'll be able to answer you questions, basic questions and questions based on the process itself, on how to file or how to change addresses or just how to find information on what you're looking for. Next slide. The patent public search tool in particular is something that we were able to enhance specifically during COVID. So before you had to go to a specialized area, to one of the regional offices or a resource partner like PTRCs, which I'll talk a little bit about later, in order for you to access the PTO database. But now we're able to have it in a web-based application for you to access at home. And this is usually number one step for individuals trying to look up patents or look up prior art, as we call it. Most inventions that we actually do nowadays are what we call improved upon inventions or improved upon patents. So there is a lot of art or technology out there that's they individuals kind of use to improve upon and do their new technology. So we always recommend for individuals to look up what's already out there, not only in the commercial area, but also it's already been out there for previous year, because that can disqualify your new patent if you're going after. So it would save you a lot of money and time if it's something that's not patentable. So next slide. Our more popular training just overall is our trademark basics. And this one in particular, just because a trademark to really apply to most businesses out there. And it really helps them understand the trademark process, what trademarks are, what they can do, and also the filing behind it. Success rate for filing yourself for trademarks a lot higher than patents. So that is something also that you have as a right, do pro se, do it, represent yourself and, do these applications. So we definitely recommend people to understand the process before filing. So next slide. And we also have a 1-800 hotline specifically for trademarks. Next slide real quick, Jason. There we go. So that's a 1-800 hotline for trademarks, and then they also have an email. So next slide, what do we have? So do know that for patents, it can be costly, like I mentioned, but we do offer small business and micro entity status reduction of fees. So for micro entity status, 500 employees and below, and then you have to qualify one of the two ways for gross income or higher institution. You can get up to 80% reduction on patent fees. So do understand that most of the fees and most of the costs that individuals run across during the patent world are actually going to go from or come from the drafting fees of an IP professional, like a patent attorney or a patent agent that helps you. And a lot of it is because you need to know the legal verbiage and the technical background to really be able to construct your rights in order to file for the application. And like Jason mentioned about publication after 6 months, that's something that can actually hurt your application because you may be disclosing something to the public, um, and it can end up hurting you in the long term. So it's something to really consider, and make an informed decision on is how to file and when to file and how to go about it. We can definitely sit down with you and talk to you and educate you. But at the end of the day, entrepreneurs and organizations and businesses have to do their own decision. So next slide. Our more popular program is the USPTO Patent Pro Bono program. This program in particular helps you get pro bono assistance for your patent application. You do have to fall under some income requirements, knowledge check, and an invention check, which is filing a provisional application. But if you're able to qualify, it helps you tremendously because, like I mentioned, drafting fees are from an IP professional is typically the highest cost that you'll see in the patent system. And do know that, the Patent Pro Bono program has coverage in all 50 states, even if the program is not within the state itself. So next slide. Here in Texas, we have TALA, which is Texas Accountants and Lawyers from the Arts. They're located in Austin. And we work a lot with TALA doing trainings and other outreach activities. And I know they're very active and they help a lot of entrepreneurs and small businesses obtain pro bono services. They actually also do other legal services, but we mainly work with them with the patent pro bono side. Next slide. Another form of pro bono assistance is law schools that we work with. So in this program, we work with second and third year law school students under a clinic supervisor to give you assistance in patent and trademarks. That way, it's a win-win situation. They get the experience and you get the drafting covered through their trademark clinics. There are more clinics out there. They're not USPTO certified, but the ones we have on our website are specifically USPTO certified. So they go through vetting and some reporting through our agency. So here in the state of Texas, you go to the next slide. We're pretty fortunate because we have four: Baylor Law School, South Texas School of Law in Houston, SMU, and Texas A&M. And some of them can do both patent and trademarks, and some of them would just do one specialty. But like I say, we're pretty fortunate to have quite a bit of coverage here in the state of Texas. Next slide. The USPTO pro bono program helps you, or PTAB pro bono program helps you also get pro bono assistance for any ex parte appeals that you may have to the PTAB. So this one in particular helps it still falls under the income requirements as well, but it's based on, or it was really developed because we kept on hearing feedback from the public. So that's one of the good things about this program in particular. Just listening to what the public's telling us and being able to enforce is not always the easiest thing. It's not something that we really get involved with. We want to get involved in to the actual filing of the application and the education. Enforcement is something that you as an entrepreneur or organization has to be responsible for. Once you get the patent, it's your responsibility to enforce it. Same thing with the trademark. Next slide. The biggest resource that we have, because we continue to expand this one, are patent and trademark resource centers. And this is where we train public librarians so they can help you with patent and trademark research. And this is just a valuable resource to the community because having individuals at public libraries giving you one-on-one assistance and just hand-holding you through patent and trademark searching is a big benefit. It's not the easiest thing to learn how to do the searching. Trademarks is a lot easier than the patent side, but patent in particular can get pretty complicated. And this is one of the reasons why we focus a lot on that specific training and try to provide as many resources as we can to the community. So next slide. We do have expedited examination programs, and this is a way to help get your application expedited through examination. So there are certain programs in general that are what we call community good, like the Cancer Moonshot program, for example. That one helps technologies with anything that has to deal with cancer treatment or cancer prevention. They can help get expedited. Same thing for climate change mitigation. We do have one in particular now, which is called the First Time Filers Program, and that one's for new filers that have never been an inventor before in a patent. And then we also have one for semiconductors under the CHIPS Act. And then you also have the right to pay, kind of like a Disney Fast Pass for a product examination. That one you do have to pay for, but it helps in case you wanted to expedite the examination. Next slide. We do have a IP journey, click on the IP identifier, an assessment tool that helps you go through a series of questions, helps you identify what your IP hits or what it can help identify. And a lot of times you'll see an overlap within copyrights and trademarks. But it's a good questionnaire, more educative to help you identify IP and your knowledge of IP. Next slide. And then definitely follows on social media. We're actually one of the finalists for an award for our social media content. We provide a lot of information and just for the public. We kind of geek out on IP here. So a lot of interesting, policy updates and just events that we're doing throughout the nation, or really the world, because we even do collaborations with other countries and just IP education and things to know. And then the last slide, I think is just our office information. So feel free to reach out to us in case you want to have a one-on-one conversation want to visit us at the office or just want to talk about IP, there's our phone number as well. Now there's a question. So from Savita, I have tutoring institute and prepared my own material over the years. I have published multiple books on Amazon. So my question is, how do I get copyright on the material which I prepared and use for tutoring purposes? So for copyright, you would have to go through the U.S. Copyright Office, and that's the easiest way of IP protection that you can get, just sending a tangible subject to the U.S. copyright for certification. And you just, I think it's like $75 now. I don't remember honestly, but the U.S. Copyright Office handles the copyright registration. Do know that you also have copyrights don't necessarily have to be registered, but it helps with the enforcement side of it to have them registered with the U.S. Copyright Office. Creative arts or we call artistic works can are fall under common law copyrights. Is there any other questions from the public? I don't know if we can open it up, um, Christine or Caitlin, to the public in case they want to ask questions. Just
Anyone with a question is welcome to enter it into the chat or the Q&A box, and we're happy to answer those questions.
and thank you for putting those links in that question. Yeah, we work a lot with the U.S. Copyright Office, what we call our sister agency, but they typically are better suited for the U.S. Copyright Office. Are there any courses offered to the public to train on USPTO similar to what is offered to librarians? I mean, I would say the similar presentations. If you go to our website under trainings, event trainings, I think it's events, uspto.gov/events. You'll see a list of all the trainings in there. And a lot of that training, that content, at least, is something that we train librarians to do. The only difference is it's more focus for a train to the trainer concept when we do librarian training. So we're trying to teach them to understand so they can do more hand holding. But the content in general, patent searching or trademark searching, we focus on. So it's something that an individual can learn by themselves. There we go. Can you go back to slide 57? That's a good question for Jason. Do you know what slide 57 is, Jason? Is that one, the IP journey or the IP identifier? Okay, I think
Yeah, that's
so.
it.
Great. Still open to questions for the U.S. Patent and Trademark Office. And thank you so much, Ray and team, for presenting all this wonderful information. Excuse me.
No worries, it's what we do. Yeah.
It's
I
very
know
interesting.
when we did the in-person Plano training, we had a lot of questions, a lot of interaction, but I think that the virtual side is a little bit more shy. What does it mean to identify your IP assets? Mm, I mean, I don't necessarily understand the question, but I would say like IP can be an asset. It can have value. Technology, for example, I think it was one of the big examples that we use is like I think it was Jawbone. It was a company that had a lot of Bluetooth technology. It went under, but the company itself had a lot of patents, and that way that those portfolio of patents is what we it became IP assets. So that's valuable assets for other companies to acquire due to the rights that it contains. So trademarks the same way, if the Coca-Cola and the McDonald's brands, those trademarks carry a lot of IP assets, a lot of weight per se, and they can actually put some numbers behind it. Another one that kind of comes into my mind is the Dallas Cowboys. They're the only NFL franchise that has trademarks outside the NFL. And that's one of the reasons why they're more valued than other franchises as well.
It's very interesting.
Mhm.
Thank you for that. Any other questions? Well, we have people here to answer them.
I used that Dallas Cowboy example last week when I was in Baton Rouge. They like to mention I'm just the Dallas Cowboys. Yeah. But it's an example.
Right.
Mhm. They appreciated the content. They just didn't like me mentioning the Cowboys.
Right. All right. So do you want to go ahead? I don't know if the person has gotten enough information off of this slide. If you wanted to put your contact information back up
Mhm.
so that people can find you. We so much appreciate that the team here being available to present this wonderful information and take questions. Are there any other questions before we say goodbye? And thank
Like
you
I
so
said,
much.
just feel free to reach out, especially with IP matters. You may not want to disclose them or ask questions publicly, so we can always accommodate and make some time for you guys and have one-on-ones, either in person or virtually.
Wonderful. Well, thank you so much. We appreciate your time and look forward to the next time. And we will conclude today's program with a great thanks to the U.S. Patent and Trademark Office, and thanks for those of you who have joined us today. We hope that you will check out further Plano Public Library programs to help with entrepreneurs and small businesses. And that is you can find on our website, planolibrary.org. And there is a tab for business and mentorship programs. So thank you very much. Appreciate your time. Have a great day.
Thank you very much. See you guys.